Hello, people. I'm back. Yeah, it's been a long time. Been doing other things. Um, One of the things I've been looking at in great detail is this particular video that I'm going to talk to you about today. Yep, I hope you're going to like it. Get your questions coming to me as much as you can. So this is about a particular idea that I've been bouncing around in class the last few weeks, months, and it's the concept of the civil state. It's not really one that I've dwelt on much in the past. And so I should probably give you some definitions before we start off. So here's a bit of revision. This should all be old hat to you. However you get to your society, whether it's a rational model, as the liberals would argue, an organic model that emerges naturally, as the conservatives would have, or a necessary sort of pre-existing condition, as your socialists would argue. And of course, there, when I'm talking about social networks, I'm talking about real social networks, not anything coming to us courtesy of Zuckerberg or one of the other Muppets. The general idea, the important thing here is that we have a society. Now, society is all well and good, but society needs some sort of rules. There has to be some sort of pre-existing, some sort of agreed set of rules that everybody is happy to go along with, and that will help us get along together to create that sort of civil state. Now, the civil state is that set of rules. It's the common regulation, if you will. But in order to achieve that, we need a constitutional settlement which sets up the offices of state and the general right ideas of why we're here. Anyway, I'm going to go into all of this in a bit more detail in the next few slides. The most important idea here is this concept of the civil state, this idea that we have an agreed set of rules and regulations. There's an agreed organization, there's an agreed network that we all sign up to. And then the question becomes, okay, fine, we have that civil state, but who's in charge? Who engineers that civil state? Who are the architects of our civil state? And what this video is designed to do is to go into that concept of the civil state and look at the difference between the civil state in the United Kingdom and in the United States, and to see what that helps us understand about these various structures and the various constitutional settlements that we have working in these two different models. Right, so onwards. The UK constitutional settlement. Now, we don't want to go into this in too much detail. The most important bit really here is that the UK constitutional settlement emerged from the mists of time. What is the UK constitutional settlement? Well, it's rather this idea, and of course Dicey would have said this because he was a lawyer, but the general idea was that the constitutional settlement is only really evident in retrospect, that we look back through our common law history. And I've had quite a few spats with some keyboard warriors recently get very excited about the Magna Carta and how it's fundamental to British democracy. It's not. Okay, it's there. It was in 1215. We've moved on. It's still part of our history. It's still part of our constitutional history, but it has been superseded by a whole new set of rules and regulations. And the important thing here is that those sets of rules and regulations can be seen, they have their roots in this constitutional settlement. But these new rules and regulations are basically these three most important things here: the rule of law, parliamentary government, and parliamentary sovereignty. And when we take those three constitutional pillars together, I mean, again, these have emerged from the mist of history. We're looking at 2,000 years essentially of common law. What we get is this idea of a parliamentary system, that Parliament is in charge. If we take the rule of law, parliamentary sovereignty, and parliamentary government together, then quite clearly what we're seeing there is that Parliament is in charge. And that's not as necessarily a bad thing, because we vote for them. If you're going to say, well, I'm going to base my constitutional settlement on Magna Carta, well, that's stupid, because you're basing it on something that was drawn up in 1215 by a bunch of self-serving barons who were sick of being pushed around by a frankly pretty rubbish king. Our constitutional settlement now is based upon a parliamentary system, for good or ill, And if you've got a problem with that, the general idea is that you don't get on your keyboard and make all sorts of comments about how we should be ruled by the Magna Carta. You vote for somebody, or you vote for somebody else, or you change your vote, because Parliament is in charge. Now, our constitutional settlement then is these 5 constitutional principles: the rule of law, parliamentary government. That puts Parliament in charge. We have a parliamentary system. What that means is that the Constitution is, at any given time, what Parliament says it is. And Parliament can change the Constitution. Every time Parliament writes a law, the Constitution changes. Because the Constitution is essentially whatever Parliament says it is. I'm going around in circles here. The important point, however, is that Parliament, because it's sitting in the centre of our constitutional settlement, it gets to define what the civil state is. So how do we define the civil state? Well, now we go to our constitutional sources. And you should remember that, well, we used to have 5, now we've just got 4. And of course, the most important of these constitutional sources, because we're living in a parliamentary system, is statute law. So your works of authority, your constitutional conventions, the common law, that's all well and good. But we're running in a parliamentary system, and Parliament gets to define what the civil state looks like. And again, if you've got a problem with that, don't get on chat rooms and start banging on about the Magna Carta. Get involved in politics. Vote. Join a political party. Do something constructive rather than just banging out angry comments on YouTube channels. The point is, we have a parliamentary system. Parliament gets to define what the civil state is. Now, the civil state is described by these 4 ideas here. We used to have treaties and laws of the EU, but then Parliament decided, no, we're not going to have that. And so we don't have that anymore. We used to have a much wider right to protest, but after the police PCOS, we're seeing that restricted. We used to have all these different rules and regulations concerning public health. Now we've got the Public Health Act 1934 and the Coronavirus Act of 2020. We used to be able to have firearms. Then we had the Firearms Amendment Act, 2 of them in 1997. Bang! Our constitution suddenly changes at the will of Parliament, because Parliament is in charge. We have this democratic system where our democratically elected officials are able to shape the civil state. Good. Now, what then is the role of the judiciary? Well, the role of the judiciary in this country is to uphold the will of Parliament, not to challenge government, not to challenge Parliament, and certainly not to uphold the Constitution, but rather to uphold the will of Parliament. Now, if the will of Parliament is the most important engineering element, if it is the most important construction element within our civil state, then you can argue that the job of the judiciary is to uphold the civil state as described by the will of Parliament and all of the other things, including common law, blah, 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 blah. But most importantly, the role of Parliament, the role of the courts, is to uphold the will of Parliament. And in doing so, to respect the rule of law and the principles of natural justice. In other words, to act in a way that is both independent and neutral. Now, let's just go back again over the most important bits of this particular thing, because it's going to be very, very interesting when we come across and we look at the American system. Because our constitutional principles, then, we take our constitutional principles, these emerge from the mists of time, a la Dicey. We decide that the most important ones there are the rule of law, parliamentary government, there we go. And that gives rise to a parliamentary system. Now, in a parliamentary system, Parliament gets to define what the civil state looks like, and the role of the judiciary becomes upholding the civil state, particularly upholding the will of Parliament as expressed through statute law. Again, parliamentary system, a Parliament is in charge. Parliament gets to decide what the civil state looks like at any given time, what the Constitution looks like at any given time. And any time Parliament passes a law, the Constitution changes, okay? Because the Constitution is essentially this bit here. It's the practical application of those constitutional sources that we were looking at earlier. Any questions, put them in the chat. I'll be delighted to answer them. But as long as you can get your head around this relationship between Parliament and the civil state, we should be okay, because, of course, that will then help you understand that the role of the judiciary is basically there to support Parliament. Parliament passes a law, the role of the judiciary is to decide whether or not that law ever gets broken. Okay. Right, let's have a look now at the United States. Now, their constitutional settlement is very, very different, because obviously we start off with the Constitution. We have this Constitution, 1788, 89, very hard to amend, blah, 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 blah. When we look into that Constitution, we see quite clearly that the legislature and the executive are given the role of creating the civil state. Interestingly, for those constitutional nerds out there, remember that the Congress is Article 1, President is Article 2, which is just something to bear in mind when you're talking about the presidency in essays, or if you're looking at checks and balances in the American system. Anyway, Congress, the executive and the legislature, both at the state and federal level, again, which one's more important there, federal or state? States have police powers. They get to shape an awful lot more of the civil state than the federal government does. Anyway, that's a conversation for another day. That's another video that's coming up, by the way. Now, so the civil state then becomes that public policy framework, and it is described by laws drafted at a state and a federal level. Now, agents within that civil state have the right of judicial review, as they do in our country. Of course, we have judicial review here. Judicial review is when a law in the UK is broken. Judicial review in America is different. American judicial review is about the constitutionality of executive and legislative action. Straight away here, just looking at this video, you can start to see where the problem is, because with our system we have something like that, whereby our courts can only ask, well, has somebody here acted unlawfully or broken a law? In America it's very different. Here what we're seeing is not so much that legal review as constitutional review. We do not have that. And because judicial review in this sense in America is an extra constitutional power, it's a power without a check. From everybody else in America, they get a power, there's a check on that power. There's nothing about judicial review in the Constitution. It was assumed after Marbury versus Madison, 1803. And of course, because it's outside the Constitution, it follows that it's going to be outside the system of constitutional checks and balances. It's easy. This is why we wind up with this judicial tyranny. So, what that means is that SCOTUS has the final say in shaping the civil state. Now, again, contrast that with the United Kingdom, where Parliament gets to shape the civil state. Parliament is there to shape the civil state, and all our courts can do is to tell Parliament when it has broken its own rules. In the United States, there's this extra level of accountability, and it's given to the courts to wield. And so, effectively, executive and legislative action in America is provisional. And the shaping of the civil state, the final arbiter, the final engineer of public policy in the United States is the Supreme Court. Unless of course, well, even when they decide not to exercise judicial review, when they refuse certiorari, they're still essentially making a policy decision at that level. So, in the United States, SCOTUS has the final say in the nature of the civil state. Any decision made by other agents in the state is provisional pending judicial review. And of course, that's really, really important, because if we go back and we look at what is a democracy, you'll know from my very first videos that I argue a system of government is a system of government predicated on popular sovereignty. Well, let's go into that in a little bit more detail, okay? We've got that as a sort of working model. What does that actually mean? Well, what it should mean is that a democracy is a system of government in which the policy and the legal sovereigns are answerable to the political sovereigns. Now, in our country, that is definitely true, in that it's an interesting question. The government, the policy sovereign, is not immediately answerable to the political sovereigns, but the legal sovereigns are. And funnily enough, in America, if we look at that, it's the same, in that the policy sovereigns in America are essentially the courts. But they're even less accountable, even less answerable to the people than our government is. We can essentially get rid of our government if we vote out if we vote for a different parliament. In America, you can't get rid of your courts. So in America, your policy sovereigns, by default, are effectively your judges. In the UK, your policy sovereign, as we know, is the government. Legal sovereign, that remains in the UK Parliament, in the United States Congress, both state and federal. And to what extent are they chosen by, accountable to, on operating the interests of? Policy sovereigns in the United Kingdom, government, you're looking at chosen by, accountable to, and operating in the interest to, at arm's length at best, or once removed. In America, the situation is even more complicated, in that the courts are certainly chosen by people who have been accountable to, blah, 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 but they're not necessarily accountable to or operating in the interests of or chosen by. Anyway, I think I've made my point, and I think I'm about to run out of time. So I'm going to blow that one up there. When you're looking at this question, think about, who is the policy sovereign? Who is the legal sovereign? To what extent are they answerable to the people? And what does that mean for democracy? And that should raise some very, very interesting questions for you if you're looking at democracy in the United Kingdom, democracy in the United States. And I look forward to answering your questions as they come through. That's pretty much it for now. Please do like and subscribe and share this video if you found it useful. If you didn't find it useful, well, you can let me know as well. If you think that we should still be running the country on the Magna Carta, then I don't think we're ever going to see eye to eye, but I'll happily indulge those questions as they come through. Tremendous. Thank you all very much. Speak to you soon. Bye now.